Hi, I'm Justin Newton. I'm the founder and CEO of Netki. We've been working in the blockchain space for about 4 years and have been focused around building tools to help with the mass market adoption or commercialization of blockchain technology. For much of that time, we've been focused on digital identity and particularly how identity relates to risk and compliance, so a lot of the topic we have today. So we do a lot of work around KYC, AML, accredited investor validation, and those other kind of pieces of identity related to compliance.
I'm Vinny, co-founder and CEO of Civic, the digital identity platform. We did an ICO last year in June. Essentially what we're out there doing is we're building a marketplace that allows people to do ID verifications and KYC and AML verifications through a marketplace structure and making KYC reusable, so you don't have to go and give the same information multiple times to different organizations. And we're also doing it in such a way that you keep control of your data. It doesn't sit on a central server at Civic, it's always on your devices. If you lose it, then you have to restore it yourself. But if you get hacked, that's also your problem. But your problem is not everyone else's problem. So when we see hacks taking place at places like Equifax and Experian, and 150 million user records get leaked and stolen, yours won't be part of that if you're with Civic because you keep control of your own data.
Hi everyone, my name is Josh Boehm. I'm an attorney at Perkins, Coie, a law firm. We commit our technology transactions in privacy practice and an active member of our blockchain technology and virtual currency group. And we have about 40 or 50 lawyers working pretty actively in this space, advising a number of companies across the industry, folks involved in tokenization applications, exchanges, custodians, funds, and so forth. It's been an exciting few years, and we're looking forward to developments in the area.
I'm Greg Mocek. I live in Washington, D.C. I'm a partner at Overy. We have 47 offices around the world, servicing clients both in the financial and corporate side and various industries. One is the Fintech space. I'm probably the least techy person in this room, so I warn you of that in advance. But my space is particularly in the commodities and derivatives. So I was in the Bush administration and ran enforcement for the Commodity Futures Trading Commission. And I know to the flip side, I do regulatory advisory work with respect to commodities and derivatives and defend companies and individuals around the world who are investigated by the federal government.
Awesome. So I'm Mike. I'm the new moderator of this panel. You might remember me from this morning. I'm the co-founder of Hydrogen. So what we do is we're a Fintech app building platform, open API platform for around the world. So I'm happy to moderate the panel and talk about my favorite topic, RegTech, everyone's favorite topic. So I have a list of questions. Some of the panelists have given me here. So first, to start off, just if you give some background to the audience in terms of the CFTC or the SEC, what are the general thoughts on what authority they have to oversee this new virtual currency market? And whoever wants to start there.
Sure, I can start with the SEC question. I think it's been, their authority has come into public view most notably with the explosion in token sale activity over the past couple of years, and whether tokens that are created and sold are securities. There's a test. A lot of folks in the room have probably heard of it. The how we test for investment contracts ask whether there's investment of money in a common enterprise with the expectation of profits through the managerial efforts of others. And so even if you don't call it a security, it can still be a security if it meets those criteria. And the SEC has come out with a few actions making clear that just because something is decentralized doesn't mean that it's exempt from the federal securities laws. They said that first last July in connection with the Dow report. And then they had a few actions since then, one involving a decentralized food rating company called Munchie, where they said, hey, we're just a so-called utility token. We're not, you don't have ownership rights, dividends, or anything like that. But because of how they marketed their token, they said, look, people can expect investment gains through future efforts we're going to do to build value. That was still enough in the SEC's view to be a security. So to wrap this up, there's a line that's kind of that's emerging. There are tokens that I think are pretty clearly securities, and there are some that, and those ones need to either register with the SEC or comply with an applicable exemption from registration. And then there are ones that, in our view, can truly be utility tokens that are not securities. Those need to be selling something that is a truly usable access to a good or a service, and that you're really selling something that people have a consumptive intent rather than a speculative intent. And it's a very facts and circumstances dependent thing, and you have to look at it case by case.
So, with that being said, what kind of oversight do you think the CFTC would have globally? So, let's take, for instance, Munchie. If they're just operating in the U.S., what right does a foreign regulatory body have over that? Does anyone want to weigh in on the global implications of regulation? Who oversees who, where? It doesn't matter where you're based, where you're doing business, etc.
So the CFTC, as everyone knows, has declared that virtual currencies are a commodity. It's less certain with respect to tokens. Tokens can be a commodity, they might not be a commodity. There's less certainty there. But in terms of the virtual currency market, they have declared it as a commodity. And the way they regulate spot commodities is that they don't regulate it. What they do is they have the ability to go after fraud and manipulation in the spot, what we call the cash market. So with that, you won't see any regulatory efforts unless we may see something down the pike. And this has been traditional throughout the commodity space ever since the CFTC was established in '75. They never wanted to be the regulator of the cash side of the market. Now, if the commodity itself is then traded as a swap, or traded as a future, or traded as an option, or on a swap or a future, then you get in a situation where the commodity is regulated, they have the ability to pursue their full panoply of regulation. So with respect to international, the CFTC takes a pretty broad view of its jurisdiction when it comes to interstate commerce. And so what they say is, and it's unfortunate because a lot of people don't agree with this, post-LIBOR, you saw the LIBOR cases and a number of the other cases that were global in nature, but this is their position, is that if someone is, for example, manipulating a market that has an impact on interstate commerce, the CFTC takes the position that they have a right to go after that misconduct. So we've had investigations at our firm, for example, in Switzerland, we've had investigations in Singapore, we've had investigations in South America. They're all over the place because commodities are inherently global in many respects. And so with that, you'll see them crossing boundaries on a day-to-day basis.
So I think all of us on this panel would probably recommend that you seek counsel to go over what your specific issues are, because these things change based on what your application is, etc. And I am not a lawyer, but you should probably talk to one. But an easy way to think about it is if you are in a jurisdiction, or you've registered your company in the jurisdiction, or you have a customer/investor from that jurisdiction, then you should assume that you're covered by that jurisdiction's regulators. So, if you're registered as an overseas company, and for example, you have one US investor in your token sale, many of the US regulators will take the view that they have jurisdiction over your token sale as a result of that one US investor. The same is true that Singapore feels that way if you have a Singapore resident, etc., so on and so forth. And so you actually see, and by the way, in the United States, that might be if your business is considered a money service business, that in addition to the federal regulators, you have a state regulator in I think 46 or 48 of the states that could also be regulating you. And so this is actually, as you start to design your product and design your platform, this is an important discussion for you to have with the council that you're working with to understand how where you take your customers from may affect your regulatory requirements. And some examples of that we've seen in the blockchain space where people have made choices as a result of that is, there's a number of token sales that won't take US investors because until the SEC and other stuff, they're located overseas, they were going to get most of their money overseas anyway. It just wasn't worth taking a US investor. In other cases, we've seen cases where companies have left New York, the state of New York, or won't do business with residents of the state of New York because of the BIT license. And so, in some cases, your strategy may be to comply with regulation based on jurisdictions. In other cases, your decision may be to exclude those jurisdictions from your service as a way to avoid taking on potentially a lot of cost for a minimal additional benefit.
I would just add one thing to that. That's I agree entirely with everything there. But even if you think you're just not selling to any U.S. investors, the U.S. securities law still can't apply, depending on how the company is structured. You may have to put in flowback restrictions to prevent securities from coming back into the U.S. in the secondary market. That's so-called regulation S, and there's a number of specific requirements. So even if you think, well, I'm just going to do it overseas and that's fine, you still probably want to talk to a lawyer to make sure you're complying with the specific requirements for that exemption.
Do you want to give a viewpoint from Civic, maybe, on how you view regulation, both from token offering, I believe that you did an ICO, and also from just offering your identity management solution? How do you view it on both ends? Because you're facing both investors who invest in the token, and then now customers. And you're dealing with a very regulated space in identity.
Sure. So when we did our token sale, it was June of last year, before the DAO sort of report came out from the SEC, and I think that was kind of a bit of a defining moment in the industry where I think they got a lot more aggressive after because that's effectively guidance that they were giving at that point. So we did accept token sales. We accept buyers everywhere, worldwide. We didn't have a restriction. We defined ours as a utility token. We showed how it worked, etc. So, from our perspective, I think times have changed. I think it's you can't do that right now, and I think it's very clear. But we used Perkins actually when we did ours, and at the time, it was just it's a very grey space. There was just no clarity on what the rules or regulations were. And then as time progressed, and there was guidance from the SEC on that, and a lot of other token sales went out, and there was a lot more sort of a working knowledge base of how to do these things. It became a lot more restrictive. So as a company, we focus on KYC enablement, really, and AML enablement. And so what we're seeing now is exactly that. People are excluding US citizens, so they want to do the KYC to figure out who's from the US and who's not, so they can exclude them. Or if they're doing a SAFT or some sort of a security sale where they're selling it as security, they'll exclude non-accredited investors and in fact non-US investors. So it goes both ways. I think depending on where the companies are based, the jurisdiction they're in, how they set up their corporate structures, where they're operating, they kind of pick and choose what slice of the market they want to take.
So to follow up on that, there's a lot of talk in this conference about utility versus security versus commodity, and now the IRS uses property. Can you have something that's a utility also be a security, also be a commodity, vice versa, in any order, or do these have to be mutually exclusive in how they're termed by the regulatory bodies?
So in the securities versus commodity space, I'll let you talk about the utility. You have a perfect example of that is with Treasury bills and Treasury notes. Treasury bills and Treasury notes in the United States are securities that are traded amongst market participants. Once you wrap that Treasury bill or Treasury note into a futures contract, it becomes a commodity. And so what you have is a situation where the commodity or the security could be duly regulated by both the CFTC and the SEC. If you trade options on a note or a bill and it's traded on a national securities exchange, it is a security. You trade options on a note or the bill and it's not traded on a national securities exchange, it is a commodity. So it's a situation where it clearly could have a contract, whether it be virtual currency or token pin, or what it is, regulated by two separate regulators.
I think as a general rule, I think that's exactly right. You have to look at the specific regime of that regulator, and it's very frustrating for folks in the industry, I know, but there isn't any sort of mutually exclusive thing. You can have overlapping concepts applied by different regulators who are following their statute and regulations. As to the specific question about the security versus utility tokens, I mean, there's just a lot, we just don't have a whole lot of guidance on some of these issues right now, but based on the law that's there, I think one thing that's important to distinguish is what Vinny was saying, how there are these so-called private placements that are SAFs, civil agreements for future tokens, that are structured as investments. They're intended to be that. They rely on an exemption from registration, but they are an investment contract. And they essentially say if somebody puts in money to fund the development of a project, then once that's done, you will get a finished product, a token, which is, a lot of sellers say that this is intended to be a commodity, something that can be used. And so I think there is an argument that those are two separate things. There's an investment contract and then something that's usable, a tangible commodity that might be delivered at the successful fulfillment of that investment contract.
What are some of the risks now to companies like ourselves and thousands of others that have tokens that are traded and are going up and down on different exchanges around the world, both to the companies but also to the end token holders or traders? What are the regulatory risks in the future? Because as you all know, a lot of what's been going on in the last few months is regulatory agencies are going backwards and telling Ethereum and Ripple, etc., that, oh no, what you did 5 years ago wasn't very good. So what are some of the landmines or the risks there for both the product companies and also the end investors in them?
Well, I think that there still is an adage in the security space that once a security is always a security. And so there is under a lot of existing case law, there's a snapshot taken at the time that the instrument is sold. And if it's a security then it's not going to change. So it does follow that, even if it was a couple of years ago, in theory something still could have satisfied that Howey test. And it has to be determined on a case-by-case, facts and circumstances basis. I think it's a practical matter if something has evolved. And, if you look at the case of Ethereum, it's widely used as a medium of exchange. It would be hard to see for me personally how that would be something that would implicate securities laws concerns in a meaningful way. But it's impossible to say without having looking at it on a very detailed facts basis.
I mean, I am not a lawyer, but my understanding is that theoretically, an investor that resells an unregistered security is also selling an unregistered security. And so there's potentially liability for reselling a token that you've purchased if it's determined it's a security. My guess is that for 99.999% of all people, that's going to be a non-issue because the SEC would never want to go after a retail investor over something like that. That's at least my belief. I think that if they saw some funds that they believed were gaming the system, then those people might be at risk in a secondary market.
So one of the things that we're seeing is, as the space plays out with security tokens and security token platforms, you're going to have a situation where these tokens that are issued and the wallets that they're issued to are all conforming to a smart contract, which stipulates who can and cannot own and trade these tokens. And so you'd have a situation where a token is designated for accredited investors only, can only be traded by other accredited investors and maybe even the ones who are existing token holders in the company, the same way we do with private shares. So these are sorts of things that I think you'll start seeing in the next couple of years, where the rule sets around compliance are actually baked into the wallets, and to some extent the exchanges and the decentralized exchanges.
I think Vinny hit on a really interesting point, how I think that there will be an increasing growth in what he called security tokens, and these are tokens that are expressly intended to be securities, and they are investment instruments. They offer people ownership in a company, you get dividends, things that you expect from actual securities. And the reason why we haven't seen a whole lot of them yet is because there aren't really good secondary platforms to trade them. You have to in general exchange these on a regulated platform, and that's why we're hopefully seeing the development of some alternative trading systems that are registered to allow that to happen. I mean, I think for a number of reasons, using blockchain technology to facilitate securities could be of tremendous benefit to investors and issuers alike. You have more transparency, speed, certainty in the transfer of those instruments. And so I think we will, and this is, and there have been states that have been changing their laws to remove the impediments to this, Delaware being one of the most prominent, to say that in the case of a public issuer, you can actually use the blockchain as your stock ledger, which is pretty exciting. And once that is cleared, it's just the same laws that apply. It's just through a better technology.
So on the commodity side, I think it's going to be pretty dynamic. I mean, what we're seeing now is that there's a large number of investigations underway, which are not public, obviously. And I think over the next 18 months, you'll see play out what is fairly typical in a market that hasn't seen a federal regulator's participation in that market before. So whether it be in the spot market or in the on the regulated side, one thing in particular that I think there's a fair amount of exposure on will be as to the trading of futures in Bitcoin. There's a heightened interest in spoofing in the market, and what spoofing is bidding or offering without the intent to execute, and it's a felony, and it's a fairly easy regulatory hurdle for the feds to use and prosecute with. And it's only applicable in the future space, so it's not applicable in spot. That being said, what the CFTC has been doing is they've been investigating and pursuing a lot of activity in that space. It's basically flash trading to try to get the market to move in one direction or the other. There's going to be that we know that there's a fair number of investigations underway in that regard. The typical stuff that you see in the commodity markets, which they have gone after for years, they'll continue to after false, inaccurate, and misleading information that's distributed into the commodity markets is a felony. And if they find situations where traders or individuals are submitting false, misleading information, they'll pursue it. The other thing, obviously, that they now have as a result of Dodd-Frank is, for the first time, they have the ability to go after insider information in commodities. And we know there are a number of investigations in that regard playing out, particularly in situations which are somewhat easy when you've got an employee who's sharing confidential information that's material with a third party, obviously there's a duty of loyalty or trust with respect to the person that he got the information or she got the information from. That's playing out behind the scenes as well. So there's enough rush tradings and there's a lot of areas that they'll pursue in the commodity space that you haven't seen them pursue before.
No, definitely. So if you, the panel had to summarize what you see as the future looking like in RegTech, in the crypto space in particular, where do you think the future lies for companies, for platforms, for exchanges, for investors? Is this going to be cleared up in the next 12 months, 24 months? What does it look like? If everyone had to give a quick 30-second blurb on the future, what it looks like.
I think that it'll be dramatically more clear 12 months from now than it is today. A number of agencies are making the noises that they're going to be clarifying, and they're starting to do so. I think that what we're going to start to see, frankly, is a lot more prescriptive behavior out of some of the regulatory organizations, and a lot more consistency in terms of what you see in the way that offerings are done, and what compliance is wrapped around those offerings in terms of tools and tool sets, etc.
So I think in the next 12 to 24 months you'll see a lot more global regulatory clarity and how at least hopefully, and how these international agencies deal with each other. I think they're having conversations already, so at least they can start figuring out how they want to handle cross-border transactions, crypto trading, etc. But if I take a 5-year view, I think a lot of the regulations and laws will be codified into smart contracts and into wallets and exchanges, and I think that's going to be something which I'm looking forward to, because then compliance spaces get dealt with as a it's like a background process that just runs, and you have to think about it. So that's the end goal, right?
I agree with everything that's been said. I think there will be some phases. I think in the next 6 months or so, it will be mostly guidance through enforcement. But hopefully, not too long after that, we will have more, what you might call it, not enforcement related guidance from regulators in terms of no action letters. I think it's very important that good, reputable industry players, such folks up here, and others are, engaging actively with the authorities and trying to. What's that? Oh, sorry. Yeah, no. Going ahead and trying to say, hey, this is how the technology works. Here's how it can really benefit, everyday consumers, and here's why there needs to be clarity on these important issues. And so hopefully that will be more of a 6 to 12 month thing. Then after that, then there's time for legislation and regulation as needed to plug the additional rules.
Skip over me for a moment while I give myself a moment to think.
Okay.
Hi. Sorry I'm late. I had a scenic tour of Los Angeles. So in the next 12 to 24 months, what do I think? Well, I think, if you look at what's happening with security tokens, and also, the artists formerly known as utility tokens, at least in the US, I think we're going to see a continued bifurcation. I think, for utility tokens or purported utility tokens, we'll see a lot of those be entirely outside of the US, avoiding all US persons until there is more clarity in the US. And I think for those in the US who pursue security tokens, I think what we're going to see is it's not as simple as people think. And I think that there will be a lot of regulatory outreach and sort of massaging as you kind of see what happens when you have a token that is issued as a security, yet it really has some fundamental utility, and that has to be addressed somehow, and it might not make the most sense with a brokerage account. So I think we'll see a lot of that sort of bifurcation, and hopefully continued education both for consumers, founders, and regulators.
When the chairman of the CFTC recently testified on Capitol Hill in front of Congress, he had a lot of questions about what was happening in the space. And not only from Democrats, but from Republicans. From Republicans that traditionally have never spoken out for regulation. The issue is, like everything else in Washington, the more pressure you get from constituents, that tends to push regulation in one direction or the other. I'm not a fan of regulation, and I don't think the current chairman of the CFTC is a fan of regulation. However, I do think, as a result of pressure that has been building up on Capitol Hill, from mom and pops throughout the country, from people who are on the retail side in particular, the fact that maybe not everyone is paying their taxes in the space, all of that is building. And so I think what you'll see ultimately is more regulation as a result. The question is, what is it going to look like? And I think there are a lot of people right now in this space, at least from what I can tell, talking to people like Joshua who does it every day, is they want the good housekeeping stamp of approval. And the question is, how do you want that good housekeeping stamp of approval? Do you want it as a result of your regulatory category at one of the federal agencies or a number of the federal agencies, or do you want it from 50 different states, or do you want to operate, somewhere in between? I think operating somewhere in between is going to be really hard moving forward. So there's going to have to be some decisions made, and sometimes, although most people talk about the swamp in Washington, there's definitely some benefits to a certain degree when you've got overlapping authority with the states moving in versus the feds. There's an interesting thing under the Commodity Exchange Act that could be applicable here. Matter of fact, is the fact that there's preemptive authority under the CEA, and take for example, if you have a futures commission merchant or an introducing broker, those entities which buy and sell futures contracts are registered right now, commodity pool operators. They're registered with the CFTC. The states cannot require them to register under the state securities laws because of the federal preemption that's in place. There's a possibility that if there was a category, particularly in the area of spot, that allowed or required, obviously, depending upon what your perspective is, virtual currency operators to register, whether it be platforms or what have you, there's an argument that that category of registrant would preempt the states from regulating the activity at all. They can still pursue fraud, but they couldn't require registration. So there's some thought that needs to go into that. And I know there's some rumblings right now in the policy, at the policy think tanks that could be possibly a direction we're heading.
Awesome. I don't know, do we have time for questions? Where's the MC? Yeah. All right. Let's take 5 minutes of questions if anyone has any. Please feel free to get up and shout.
Hi, Matthew Gertler, Digital Asset Research. My question, I guess, is for Gregory, since you've been involved with the CFTC a bit. A lot of the question about the SAFT is the investment contract and risk hold could be a non-security token. Has any arguments been made of why this resembles sort of a futures contract or a forward contract, in that, well, you could have speculation in the futures contract market, but and still not be a security? Or how do you think about these issues?
There has been discussion in that regard, and if something is structured as a forward contract, there's basically a legitimate expectation of delivery whereby entities are typically commercials that are dealing in the physical forward markets, and the CFTC doesn't regulate that market, which is an interesting part of your question that you posed. That being said, there is a similar situation with what's described as leverage contracts. And I'm sure you probably saw one of the cases, actually is several of them, that have come out whereby the CFTC has said the entity is not selling spot, it's selling a leverage contract. And the way the Commodity Exchange Act is worded, you can't sell a leverage contract to a retail market participant unless you have actual delivery that occurs within 28 days. And most recently, as of May 1, there's a California court right out here in a case called Monex that called into question that very same argument the CFTC has been using with respect to whether something that's sold to retail should be traded on a futures exchange. So stay tuned.
May I just answer something just tangentially to that, and you guys, if any of you disagree with me on the panel, please say. Anyway. But the whole idea of using a SAFT right now in the US for a token that is not presumed to be a security at the end of the day is a very, very, very risky proposition. So I think even if you can get comfortable that there might be some sort of alternate path forward with the commodities angle, I think right now, given what we've heard from the regulators, if you're doing a token sale to US persons and using a SAFT, then that SAFT likely should presume that the token is going to be a security.
Any other questions?
Hello, this is Daniel Mas. Nice to see you all. Thanks for coming. Just speaking to the comment about once a security, always a security. So if you're pretty confident that what you're building is going to be a utility token, but you're preemptively issuing the sale of it in SAFT and also in your pre-sales as if it were a security, complying with 506B and even the Reg S, does that constitute an admission that it is actually a security so that when there is heavy utilization of the token downstream, you're actually sort of confessing that it is actually a security?
So I can't give legal advice on the panel, obviously. Typically, though, if you want to never say that your token is a security in the US, I mean, like I mentioned, you would offer it to non-US persons under as broad as possible a reading of US persons under Reg S. And maybe you could at the same time approach the SEC and the regulators, or your lawyers, do that to try and see if you could get comfortable. I mean, I definitely think though, if you are treating something as a security and essentially saying it's a security, then it's hard later to say, well, I didn't really mean it. That being said, I mean, certainly Chairman Clayton, it has been reported, I wasn't there, that he may have said something to the effect that, you know, just because something may be a security at the moment that it's issued, that it may not always be that way. That being said, I strongly think that if you don't want it to be a security in the US, then don't sell it to US persons right now.
Hello, thank you for this awesome talk so far. I'm from the Coie Stanford Blockchain Group, Steve Nunn, managing editor of its new academic journal on blockchain policy. Word on the street, Ripple hit with a big, well, I don't know, big, but a class action, saying that it's basically a never-ending ICO selling what might be unregulated securities to the public. Does this, I mean, is this kind of a harbinger of the future of what's to come? Is it going to have much of an impact? Is it going to be piggybacked on by regulators hungry, looking forward to such kind of sector action? What do you think?
So again, I am not a lawyer, but the last 4 companies I've been with have all gone public. And the thing that I know was true with that was basically from the moment that we went public on, all of those companies were always being sued by shareholders because it's a way for plaintiff lawyers in the US to make money. And so even, you know, in the vast majority of those cases, actually probably all of those cases, there was actually nothing there. There were myriads of shareholder lawsuits, and literally at every moment in time, once the companies went public, within about 3 months, from then onward, there was always at least one happening. It's been really slow in the blockchain space for those kinds of shareholder lawsuits and shareholder class action lawsuits, but I would anticipate that what we're seeing right now is the trickle that's at the beginning of a flood.
I feel like I'm talking an awful lot for only being here a very short time. So I think a couple of things. One is, obviously, you can never stop somebody from suing you, to your point, no matter what you do. And I think the other thing is, of course, when you hear, okay, regulators may be looking into these types of things, you know, sometimes people say, aha, and so we're going to sue. Like, like you're saying, where there's smoke, there must be fire, right? But at the same time, I think we all need to look really carefully at this, because if the regulators are still trying to figure stuff out, do we really want it to be decided by a judge who may not have been looking into this at all? So I think that that's one of the dangers for our entire industry here.
One component of the question was, I think, whether the regulators will be looking at the class actions. It's typically the other way around, where the class action plaintiffs' lawyers are sniffing out what the regulators are doing and file copycat cases. Obviously, we've seen that in every major case that came out of the derivative side by the government. The flip side was the class action bar.
I think it's a really great point that Joshua raises about how these definitional issues are decided. We're all, hoping for a little more guidance from the regulators on some of these issues. But in the interim, someone can always go to court, and some of these class actions tend to be in federal court, and those judges are free to, they will be asked to make a determination as to whether something is a security or not under federal law. And it's not the sort of thing where if the SEC even, let's say they did eventually release some guidance or informal something or other, that wouldn't supersede what a federal court said about what the law is, absent some actual change of that law by Congress. So it is important to remember that bad facts can make bad law, and there is always the potential, especially in the token space, where if a token price is high, people might be happy, but if it plummet, there may well be plaintiffs lawyers out there looking for an opportunity to get a class together and try to say, hey, I at least want my original purchase price back.
So hi there, I was wondering if there is any little possibility that Ethereum may be found to be a security under the United States law. What would happen with all the ICOs that were built upon it? Would those ICOs or tokens with this specific protocol would be also considered as a security? What would happen?
Would you mind repeating the question? I didn't quite follow. So
he basically says that if Ethereum is deemed to be a security, what happens to the ICOs? It's kind of like saying, what happens if I make a payment plane out of a share certificate? Am I like contravening FAA regulations and SEC rules at the same time? Like, just because you can use the token to do an ICO doesn't mean that the ICO is a security as well. It's the, like, you can use ERC20 tokens, you can create them using Ethereum. If Ethereum is a security, it doesn't mean the tokens are as well. Does that make sense?
I think that there are, and that's certainly right with respect to the token that's ultimately being sold, but if Ethereum, let's say just for example, Ethereum were to be a security, there would be a number of collateral consequences that would be very negative. I mean, one being if you, let's say, accepted a lot of Ethereum and you held it, you could be subject to the Investment Company Act. Registration requirements and that requirement for holding a bunch of securities. and the implications go beyond that to entities that are facilitating the exchange of Ether. There be implications under the Exchange Act for facilitating the exchange of unregistered securities. So it's the same kind of implications that exchanges are already looking at with respect to whether they want to list a certain other token or not. And they'll do an analysis of whether it's likely a security or not, and then list it if they're comfortable that it's not, and delist it if they think that it likely will be. So I think you see a similar sort of set of consequences and reactions.
Yeah, I mean, it's funny when, or maybe not so funny, but when the DAO guidance came out and thereafter, a lot of us had sort of looked at the guidance and said, okay, so the regulators are trying to take a measured view of this. They didn't cut everything off at its knees. If they wanted to, they could have, if they thought that Ethereum was an illegal sale of securities, they could have just cut everything off, said Ethereum, you're in trouble and gotten rid of all the ERC20 tokens that had been issued. So I do feel like we're somewhat down the path. I wonder though, and this is just me wondering as a person, right, not as a lawyer, but I wonder whether some of the remarks that I mentioned a little bit earlier, where it was reported that someone said that perhaps something could have been sometimes a security when issued and then not be later. I wonder whether something like that may be applicable to Ethereum if in fact someone ever made the determination that it at one time was. But I agree with you. I think a lot of, if that is the case, then there's a lot of stuff that needs to be figured out.